David Bruno, you heard the opening statement there. My comment was I didn't think he hit it hard enough. And to this idea, you know, he talked about being, you know, the snitch in the classroom or at work. This is so different from that. I wouldn't have even gone there at all. But do you think it's possible? Again, the facts are not good. He waited 9 minutes before he went back. Apparently, he went and got some food, ate some of that, had his guns, took them out, asked to be dropped off in an alley, shot him 10 times, kicked him in the head. Certainly not good facts. But do you think there's a possibility, if they can get the jury, if the defense can get the jury to understand how serious this is, that there's a chance they can get this knocked down? He's not walking out. We know that. But they're trying to knock it down from premeditated murder to maybe a manslaughter charge.
Yeah, he's not going for the gusto, the not guilty. He's going for a manslaughter. And look, for that to be negated down to the manslaughter, it has to be an adequate provocation. It needs to be subjective and objective. So a reasonable person must find that it was an adequate provocation. And I wonder, they should have expert testimony on this. Yes. Because I will tell you, the average juror is not going to get the severity of that threat. They're going to need someone to color it, to make it enough for the adequate provocation so that somebody sitting in that situation would feel so impassioned that they do something that's not purposeful. But to your point, Michael, this defendant has an even bigger problem than the adequate provocation, and that is he left. He left for 9 minutes, and you heard the defense attorney trying to say that there was no moment to think and that there was no moment to cool down, meaning that not only was there an adequate provocation, but that the defendant was still under the passion of the adequate provocation with no ability to cool down. That's the argument that the state's going to be making, is that that 9 minutes not only was a cool down and it wasn't an adequate provocation, but he planned to kill that individual in those 9 minutes. And that's why he came back and shot him 10 times, ending with kicking him in the head.
Absolutely, and the defense wants to shorten that 9 minutes to make them think it's short, and of course the prosecution wants to let them know that's a very, very long time. And Dr. Taylor, explain to me, and before I let you go, how powerful these organizations are, these gangs. They're not the gangs from the 1950s, a bunch of kids in a neighborhood. You know, these are gangs with tentacles in lots of different things, and they are really powerful organizations.
Involved in all sorts of nefarious crimes, everything from the human trafficking, drug trafficking, arms trafficking. Very, very dangerous to be involved in. And the oath that individuals take when they join these gangs is that they're in for life, and that if they try to leave, that they can be summarily killed. So it is these gangs are quite serious in terms of the types of criminality and the lengths to which they will commit acts of violence to achieve their goals. Yeah. So, it is a very unfortunate thing, very difficult thing to break out of.
Absolutely. And you know what's interesting? I wonder if Eric Holder, he turned himself in. I wonder if he felt safer in the custody of police rather than on the streets, considering the status that Nipsey Hussle had within that community. He might have been in more danger out rather than in. But thanks to Dr. Q Taylor for joining us today. Truly appreciate it. Really great to have you on the show. David Bruno, you're going to be sticking around. Coming up next,